Please be seated.
Good afternoon, everyone. We want to welcome you to the Tennessee Court of Appeals. The panel today, this afternoon, will consist of Judge Frison to my right, Judge Davis to my left, and myself, Judge McClarity. Mr. Clerk, do we have any preliminary matters this afternoon?
No, sir.
In that case, will you please call the first case?
Yes, Your Honor. Matthew Hawn v. Sullivan County Board of Education et al.
May it please the Court, I'm Janet Hayes. I'm here today on behalf of the appellants, to whom I will collectively refer as the Board or the Board of Education. I'd like to reserve 4 minutes for rebuttal, please.
You may proceed.
This case is about insubordination and unprofessional conduct leading to the dismissal of a tenured teacher. This case is not about the likability of the teacher, Mr. Hawn. And this court is not being called upon to address any complex cultural or political issue. Instead, this court is simply asked to decide whether the board had sufficient evidence from which it could determine that Mr. Hawn engaged in unprofessional conduct or insubordination. Now, before I get into the more substantive merits of my argument, there's a significant threshold issue concerning the standard of review. In his brief, Mr. Hawn argues that Chancellor Priester's findings are to be presumed correct by this court. That is not accurate. This is a teacher termination case filed in Chancery Court on a writ of certiorari. Mr. Hawn was appealing the decision of an independent hearing officer. It was the independent hearing officer who took the evidence, who heard the witnesses, and who rendered a decision in favor of the board. Mr. Hawn was appealing that decision to the Chancery Court, and the Chancery Court, under the statute, is not even allowed to consider additional evidence beyond the cold documentary record, other than on the issue of whether the decision is arbitrary and capricious or whether there's a violation of constitutional or statutory rights. So Chancellor Priester was reviewing a cold record. It was the hearing officer who was in the position to evaluate the credibility of the witnesses.
For our purposes, are we looking to determine whether the chancellor's decision was arbitrary or capricious, or are we looking to see whether the evidence preponderates in favor of the chancellor's decision? You
are looking at how the evidence preponderates.
So arbitrary and capricious is not what we're dealing with?
That is correct. Okay. If I may quote, the appellate court's role is, and I quote, to make an independent assessment of the credibility of documentary proof without affording deference to the trial court's findings. That's the standard of review for the Court of Appeals. So for this court, it's this court's role to see if there is evidence in the record supporting the board's decision to terminate for insubordination or to terminate for unprofessional conduct. Both of those terms are defined in the Tennessee tenure statute. Insubordination is defined as a refusal or a continued failure to obey a policy or a rule, or this court has interpreted it to mean any directive given by a superior entitled to give the directive. This court has also interpreted insubordination in the statute to include any defiance of authority. Likewise, the statute defines conduct unbecoming a member of the teaching profession, and it's a very broad definition in the statute. Pertinent to this case, the statute references the Tennessee Teacher Code of Ethics, and the Tennessee Teacher Code of Ethics precludes an educator from denying access to varying points of view. That's deemed unprofessional conduct under the statute. Also, the statute has been interpreted to mean unprofessional conduct includes any behavior which has a negative effect on the school system. And there's at least one case where the court has upheld dismissal where an educator showed a controversial or highly suggestive movie to high school students. Now, in this case, Chancellor Priester incorrectly reduced the issue in this case to the, quote, mere slipping of 3 profane words. But in fact, the events leading to termination evidenced a repeated failure to follow authority, failure to follow directives, and failure to follow the policies. The events occurred over the course of the 2020 academic year. And we must go back to the fall of 2020. A statement that Mr. Hawn made sort of foreshadowed the events to come. In the fall of 2020, while teaching a class on contemporary issues, Mr. Hawn videotaped himself making an assignment. This is at a time when students were remote learning, so he posted the video. In his posted video, he said, and I quote, "White privilege is a fact. We are not going to discuss that." The video, of course, garnered comments from parents who were very concerned about precluding the opportunity for discussion in the classroom. As a result of the video, the administration, acting through Dr. Brett Palmer, the Director of Curriculum and Supervision, had a very amicable email exchange with Mr. Hawn. They did not discipline him at that time, but the email exchange did pertinently include directives. In his emails, Dr. Palmer reminded Mr. Hawn specifically of the Tennessee Teacher Code of Ethics, which says teachers may not deny students access to varying points of view, and also cautioned him to be objective and to reserve his personal views. A few months later, in the same class, Mr. Hawn revisited the issue of white privilege. This time, the context was a discussion about why Donald Trump was elected president in 2016. Mr. Hawn asked students to articulate reasons why Donald Trump may have been elected, and then he made an assignment. He assigned that they read an article entitled "The First White President." It is undisputed that the article Mr. Hawn assigned to a group of 15 to 18-year-olds concludes President Donald Trump is a white supremacist, and the voters who supported him supported white supremacy. Mr. Hawn's decision to assign this article is significant for 2 reasons. First, of course, it heightened concerns about presenting varying points of view, but perhaps more importantly was the content of the article. It was littered with racial slurs, graphic references to female genitalia, and profanity. Quite frankly, the language in the article is such that I think it would offend the decorum of this court for me to speak it, but I ask the court to please look at the briefs and look at the record as to what was in the article. The board, or the administration, had a policy in place, and Mr. Hawn testified that he knew and understood. There is a policy that requires or allows parents to choose when an assignment includes racial slurs, as some pieces of literature do, or if it includes curse words, then the policy is that parents are to be given notification and they have an opportunity to preview the assignment and choose whether to perhaps elect an alternate assignment.
That's a written policy?
That is a written policy, and Mr. Hawn testified that he knew and understood that to be the policy. Upon that assignment, of course, there again were parent complaints. The board did not immediately issue any discipline, but they did conduct an investigation. During the investigation, Mr. Hawn did not apologize. Instead, he stated that he, not the parents, quote, thought the kids were mature enough to handle it. Also, his principal interviewed him, and his principal testified that during the interview, the principal said, well, are you going to present sources offering different points of view? And the principal testified that Mr. Hawn responded, there is no credible source for a different view. Mr. Hawn has since disputed that he ever said that, but he did not dispute it during the proceedings leading up to his dismissal. The investigation is significant because it led to a letter of reprimand. The formal letter of reprimand issued by the administration of the school district was very clearly a directive. And in the letter of reprimand, The assistant superintendent specifically cautioned Mr. Hawn that he must allow varying sides and perspectives of an issue in accordance with the Tennessee Teacher Code of Ethics. It also cautioned him that he must consider whether material is too mature for students and whether parental consent is needed. Mr. Hawn has testified that he understood that the reprimand meant he should be more careful with language, making sure his content's age appropriate, and use a variety of sources. The letter of reprimand also stated that future incidents could result in dismissal. Following the letter of reprimand, just a few weeks later, Mr. Hawn again revisited the issue of white privilege in the context of one of the lessons he was teaching. This time, Mr. Hawn brought in a video. He did not give a written assignment for the students to take home, but he brought in a video and he showed it to the class. The video was a spoken word poem that is on social media. The spoken word poem is called White Privilege. The video depicts the author of the poem reciting the poem that includes graphic language, curse words, references to effing my brains out, and other profane and vulgar terms. When Mr. Hawn's superiors questioned him about showing the video, he was not entirely candid. He said that he had muted all of the profanity out of the video. But in fact, a student in the classroom had recorded the video on his phone. And the recording showed that Mr. Hawn did attempt to hit mute through some of the profane language, but he missed a lot of it. The video also revealed that he had the closed captioning turned on when he started showing the poem in the video. Also, and perhaps more importantly, Mr. Hawn failed to notify parents that he was going to show the video and did not notify administration despite his warning. Most significantly—
You may finish your point, but your time has expired for this.
Oh, I apologize. If I may end with most
finish.
significantly, before he showed the video, he stated, "This may get me fired," but he hit play anyway.
Thank you. You have your rebuttal time. Yes, sir.
Good afternoon, Your Honor. I'm Rick Colbert. I represent Matthew Hawn. The incident that triggered Mr. Hawn's dismissal is the one Ms. Hayes was just beginning to describe. And this was in the spring of the 2020-2021 school year. And he had a student who, actually the class, it's a contemporary issues class. It's primarily juniors and seniors. It's an elective class, and it has no established curriculum. It evolves with whatever the events of the day. And of course, the 2020-2021 school year had quite a number of significant events that would give rise to discussion in a contemporary issues class. At the particular time, in April of 2021, the Derek Chauvin trial was going on for the Floyd murder, and one of the students brought up the subject of white privilege in connection with that trial. And so Mr. Hawn, he had the students research black privilege, and then he brought in a different perspective than what students would normally get, the students in Sullivan County, Tennessee would normally get. He brought in a video. It's been seen some 50 million times on YouTube. It's Kyla Janae Lacey, and her poem is titled White Privilege. It does have some vulgar words in it. And so the night before he brought it in, he timed out where the vulgar words were with the intent of muting them. And admittedly, 3 or 4 times during the playing of it, his timing was off.
And is the reason why he didn't seek permission from the parents under the policy for showing vulgarity because he intended to mute the video?
That's right. because he intended to mute the video. And in fact, Director Cox, who was the director of schools at the time, he testified that, that the showing of the poem would have been appropriate for the class if Mr. Hawn had been successful in muting each one of the vulgar words. It was his failure to hit mute at the right moment on every single one of them that made the poem an inappropriate vehicle for the class, according to the director. So once
Was the argument also not made, though, that part of the power of the video was its vulgarity?
Well, we presented some expert testimony about that, but the chancellor didn't rely on that expert testimony for anything. We did at the hearing, we presented some expert testimony to that effect, but the chancellor didn't rely on the experts. So because his muting efforts were not completely successful, he was fired for insubordination and unprofessional conduct, and we respectfully submit that the chancellor's decision to overturn that dismissal should be affirmed. I just want to say one thing about the standard of review, and then I'll move on. I think Ms. Hayes may have overstated her position a little bit on that. There is some law to the effect that the chancellor's credibility findings on a cold record may not be entitled to the usual deference that the appellate court shows to the trial court's credibility findings. But otherwise, this review is like any other review of a trial court's decision after a trial, which is what we had, even though it was on the record. The court is to uphold the chancellor's findings unless the evidence preponderates against those findings. So the tenure law defines, there are two charges here, insubordination and unprofessional conduct. The tenure law defines insubordination as a refusal or continued failure to obey reasonable rules or assignments. According to this court in the Morris decision and the Elmy decision, both of which we cited in our brief, the term insubordination connotes an element of intent. It's a defiance or willful disobedience to authority. There is no evidence in this record that Mr. Hawn was willfully disobedient to authority. Regarding the vulgarity in this Lacey poem, the evidence establishes without refute that he attempted to mute the words he practiced the night before. He and every student who testified that was in the class said that he tried to mute the words, but the chancellor didn't just rely on that. The chancellor reviewed the video of the video that was Exhibit 12 in the record, and based on her review of that, she found that he tried to mute the profanity. His good faith effort to mute the profanity, even if he was off 2 or 3 times, doesn't establish a defiance or willful disobedience that amounts to insubordination. Now,
This may be where you're going. What do we do with his statement that this might get me fired?
well, you know, there was really no proof in the record about what he meant by that statement. He could have meant an assortment of things. His testimony was he was just joking around. This is a class that was an interactive class. They used what they call an inquiry-based method of instruction. You're at the end of the school year, basically. You're in April with students that you've been with in this back and forth sort of class. They're mature students, and he very well may have been just joking around, but there's no evidence about what he meant by that comment. I mean, he could have just as well meant that he's been in trouble every time the subject of race and white privilege came up, and it was coming up again. So he could very well have meant that. He was in trouble in the fall because he talked about white privilege. He was in trouble in February. He was reprimanded in February over the Ta-Nehisi Coates article, which had appeared in the Atlantic 4 years earlier, because it talked about race and President Trump's election, and how he was trying to basically undo President Obama's legacy, and And I do need to point out that the offensive language that was in the Ta-Nehisi Coates article, and the reason why Mr. Hawn didn't think it was inappropriate, and he testified to this, was because it was quotes of President Trump and his advisor, Steve Bannon. So that's why he didn't think it was inappropriate for high school juniors and seniors to see that language. But there's just no evidence that he intended these students to hear the vulgar words in the Lacey poem. And his statement that this may get me fired, the school board had the burden of proof in this case. They had the burden from day one. They had the burden in the dismissal hearing before the administrative hearing officer. They had the burden in Chancery Court under the Cooper and Emory decisions. They had the burden of establishing what he meant by that statement, and they didn't offer any proof about what he meant. So respectfully, his good faith effort, even if he was off a couple of times, does not establish the sort of willful disobedience that amounts to insubordination. As for this notion, and what he was charged with was failure to offer other perspectives to students. And that's not, the charge of unprofessional conduct grew out, in this case, grew out of the provision that says it's unprofessional conduct if the teacher violates the teacher code of ethics. And there's a particular provision in the teacher code of ethics that's at issue here that says that the teacher will not unreasonably deny students access to alternative perspectives. That doesn't mean he's supposed to spoon feed them alternative perspectives, which seemed to be the school district's administration's theory, that it was his job anytime he offered something that they thought was politically liberal, that he needed to also provide the students with something that was politically conservative, even though not every issue can be painted in those sorts of strokes. Even the chancellor, in her opinion, she struggled with what does the statute mean when it says varying perspectives? It doesn't say polar opposite perspectives. And she says he did offer varying perspectives, and he did even on this video. He invited the students to research black privilege, and then he gave them an assignment after they watched the video. He had them get into groups and do research on socioeconomic statistics, basically, to see if those statistics bore out some of the assertions that Kaljanae Lacey made in her poem. So there's simply no violation of the teacher code of ethics at all here. And even if there was, this really goes to the last question, and it's a question that the chancellor addressed, but it's a question that the board did not address in its brief. We contended in our brief that they waived this, and that is dismissal warranted? When it comes to unprofessional conduct, a violation of the teacher code of ethics has to be in such a manner as to make one obnoxious as a member of the profession. Is there anything in this record that would suggest that Matthew Hawn, a teacher of 16 years with a spotless record, whose own principal said he was an excellent teacher, somehow suddenly became obnoxious as a member of the profession because he showed the Kaljanae Lacey video and tried to mute the profanity but wasn't 100% successful? This court has repeatedly said this is the second question the court always has to answer in a tenured teacher dismissal, and that is dismissal the appropriate penalty? In the Ripley case back in 2008, there was a teacher she had 8th grade students, and she threw a fit. She was kicking backpacks and throwing things and throwing student projects in the trash can, and said some things she shouldn't have said, sang a song she shouldn't sing, and This court said some discipline was justified, and I think this was out of Anderson County. Some discipline was justified, but not dismissal in light of her overall record.
Let me ask you about that, and I want opposing counsel to touch on this too in rebuttal, is this idea that you can establish the grounds for cause, but that's not enough. There's a second step, which is basically, given the cause, what is the appropriate discipline? Who decides that? I mean, it seems kind of, is that the discretion of the adjudicator? Is it our discretion to look at that and say, hey, we may find that he did X, Y, and Z wrong and meets the definition of insubordination and unprofessional conduct, but we don't think that the punishment fits the crime, so to speak, in this case?
Yes.
Is that, we decide that, and what's our standard?
Well, I don't know that there is a standard. I think at this point you're reviewing the chancellor's decision. It depends on whether you regard that as a question of law or a question of fact or a mixed question of law and fact.
Are there cases that tell us what we're supposed to do?
Well, they don't really tell us what the standard is, but they do tell us that the court has to decide it. And the chancellor decided it. She recognized that she needed to decide it, and she talked about it in her opinion that, I can't remember the exact page number, but she mentioned that this was the question she had to decide. And then at the end of her opinion, even though she didn't find that there was cause, she said even if there had been cause, it wouldn't have justified dismissal in this case. Again, in the Ripley case, I mean, and she was deciding the case de novo. That's on her. For the chancellor, she was to review the case de novo, irrespective of what the hearing officer had done before. So that was her decision to make, and Ripley, the Court of Appeals, looked at it, and the Court of Appeals said, we don't think dismissal is warranted. In the Finney case, which was the Franklin Special School District case, and that was a teacher who had a physical encounter with a special ed student, and she had a history of issues, and the court looked at it and said, even if a statutory ground, and cited Ripley, and said, even if a statutory ground is proven, the court must determine if the conduct warrants the drastic action of dismissal. That's at page 690 of the Finney case. And the court in that case said it did. Most recently, this court decided the Hubbard versus Claiborne County Board of Education case in 2021. It's a case that my adversary counsel here represented the board in that case too. And it's an unreported case. It's at 2021 Tennessee Appeals Lexus 413. And at pages 16 and 17, this court said, and Your Honor was on the panel on that case. And this court said,
Oh yeah, I remember it now.
Yeah.
Just kidding. I don't.
Just kidding. But proof of statutory grounds for dismissal does not end the matter. The question of the appropriate punishment remains, citing Ripley and Finney. So that's the issue that the chancellor decided in our favor, and that opposing counsel, we submit, waived on appeal. But even if they didn't waive it, we believe the chancellor was correct in light of Mr. Hawn's spotless 16-year record prior to this.
Thank you. Yes, ma'am.
There are a few issues I would like to address, but while it's fresh on my mind, opposing counsel has mentioned several times the Finney case, and I encourage the court, direct the court's attention to the Finney case as it pertains to the standard of review, because the Finney case is very clear, and I will quote, it says, there's no presumption of correctness given to the Chancery Court's conclusions. So with regard to the standard of review, I maintain that there is no presumption of correctness. Also, opposing counsel has made a point saying that Mr. Hawn did not deny access to varying points of view. Of course, we've talked about the materials that were presented. He suggested that he gave an assignment to explore the concept of black privilege. That assignment was not given until after the video, and it was not a reading assignment. It was just, you go look and see if you can find anything on the issue of black privilege. Perhaps more importantly, when it comes to denying access, if we look at the student testimony, and lots of students testified in this case, but following the video, there was an attempt to have conversation about the topic, and there were some students who disagreed with the perspective presented. One of those students testified that when he tried to talk, that Mr. Hawn shut down the conversation and, quote, didn't want to talk to any more about what we thought about the video. Afterwards, after class ended, a female student approached Mr. Hawn and was concerned that there were boys in the class who disagreed with the video. Mr. Hawn, within earshot of the students, said, and he has admitted, he said, they don't know anything. And he said it in a way that was very demeaning and belittling to the students. Those students who testified, one of them, and these are students who may have otherwise liked Mr. Hawn, but one of them stated that his remarks and actions were, quote, blowing off me and any other students with more conservative views. Another student said that he heard the comment, and he said, and I quote, I thought he was saying we are dumb. That's denying access to varying points of views when students are not permitted to have discussion on a topic. Another point that I would like to address is the issue of willfulness. The chancellor and opposing counsel has mentioned willfulness repeatedly. The statute, however, does not require willful action. The actual language of the statute in defining insubordination talks about a refusal or continued failure, which does not suggest willfulness to me. I have been unable to find any case that says willfulness is required. But even if it were, I'm hard-pressed to figure out what more direct evidence of willfulness could exist more than an educator standing before his class saying, this may get me fired, but then doing it anyway. And, you know, the idea that, well, we didn't know what he meant by that, I think the circumstances leading to the statement make it very evident what he meant by that. He was very much at odds with the administration. Administration described him throughout the course of these proceedings. The testimony was that he was flippant and that he had a tone of arrogance. There was not an effort to work with the administration. And then he made that statement, which is now the attempt is to characterize it as, well, it was made in jest. And I would argue, even if it were made in jest, that only underscores the unprofessional conduct. This is a situation where this educator was coached when he said the students may not discuss a topic. He was coached, then he received a written reprimand about showing inappropriate materials and his statements, and then he made this statement. It's very evident what he meant. I will conclude by simply saying I think the independent hearing officer reached the correct result, and we would ask that the Chancery Court's decision be reversed. Thank you.
Thank you. I want to thank both the attorneys for your presentation. Your case now has been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Again, thank you both for your presentation. You may be excused.